Ladies and gentlemen, welcome back to the Indie Zone podcast. My name is Kathy. What can we expect as the public to see at tomorrow's virtual hearing on the Media Coalition's motion to set aside the gag order? First, because this was the media's motion, we can anticipate that after Judge Stephen J. Hippler goes into all of the preliminary putting on the record of material information, such as the name of the case, Idaho versus Kohberger, the case number, and also why the court is conducting oral argument at all, i.e., this is a hearing on the media's motion to vacate the non-dissemination, aka gag order. A motion is an application for a court order. Media can't get on the phone and call Judge Hippler or send him an email asking him to set aside the gag order. It must be done via motion, asking for an order granting the setting aside of the gag order. Because this is the media's motion, you can expect that Judge Hippler will turn to the media. I'm anticipating it will be attorney Wendy Olson, who filed the papers on July 3rd, 2025, seeking to set aside this non-dissemination order on behalf of the media. Once Ms. Olson gives what I believe facts at issue here, principal case law legal authority, we can expect to hear the First Amendment mentioned at least one time, freedom of speech in the press, in seeking the court to set aside this gag order. After the media is heard, then it's going to be Judge Hippler that's going to get back on the record, and he will turn to the parties, the state and the defense, asking if they would like to be heard. As of right now, and I've just checked the docket, I've checked the case summary page, the only response that has been filed is by the state. So we can expect the state now to inform Judge Hippler why it is that the judge should deny the motion to set aside the gag order at this time. If the media files what's called a reply before the hearing, the judge may turn to the media once again and ask if they wish to rebut what the state has just said. Or the court may ask for that anyway, even if there's not a reply. If that happens, then the floor is turned back to the media through Wendy Olson. Ms. Olson will say a few words. The judge may say a few words on the record. He may even rule from the bench, as he has done on occasion in this case. Or he may say, I will take things under advisement and enter a written ruling later. What does under advisement mean? You've heard him say that before, i.e., at the hearings on the motions in limine. Well, that means that he's going to take what the media has filed and said at the hearing, what the state has filed and said at the hearing, anything that the defense files, and then he's going to issue a ruling later, and then the hearing will be concluded. I am interested in finding out if there is any reference to the new filings that the media just put on the record this week, seeking to open up this case even further by filing a motion, memorandum of law, and declaration in support regarding the mountain of documents that remain under seal in this case. Those filings were submitted by the media on July 14th. We know that by looking at the case summary page. They are not on the docket as of yet, but it is a motion to be heard as interested parties and motion to unseal records. So watch for any reference to that second set of filings at the hearing tomorrow. This will now conclude this episode of the Indie Zone. Thanks for joining us today.